Jim, tonight we have the Kinkade Will and Trust Dispute as our first segment.
When you're talking about Kinkade, are you talking about the artist that believed in the lighting and the pictures that bring them all alive?
Yeah, that's Thomas Kinkade, the painter of light, and he lived in Monte Sereno, I guess that's up by Los Galdas, and he met his untimely demise at age 54 due to an accidental overdose of alcohol and some other prescription drug in April of 2012.
Well, you know, that's really unfortunate because his paintings were highly successful. He had numerous galleries, and my understanding was he was bringing in over $100 million a year on selling his paintings.
Yeah, he was making bank, and what happened here, he had he was separated from his wife for about 30 years, Annette Kinkade, and he had 4 children, and the estimated fortune was about $66 million. And but Mrs. Kinkade filed for divorce 2 years before Thomas Kinkade died, but it doesn't look like they finished all the paperwork on that, so they're still technically married.
Well, that's interesting because our next subject is going to be talking about divorce and dissolution. But how did that affect this case, Mark?
Well, in the last 18 months of his life, he met a young woman, Amy Pinto Walsh, and they started, she started living with him, and was living with him at the time of his death. And I think she became his advanced healthcare directive attorney, you know, and I think probably his DPA and a couple things like that. And then he amended his estate about 5 months before he passed away. And that's kind of what the whole dispute is about.
Well, you were saying he had about a $66 million fortune, correct?
Right.
But did that include his homes in San Francisco and Monte Sereno, or is it just the inventory he had in because my understanding was there was a complete art warehouse, air controlled they didn't even talk about how much that was worth. So is 66 just like the calculable amount of the asset, or was that just the general number they put on it?
I think that's their estimate of it, but I'm sure there might be different valuations of what it could be worth. Now, one thing he had was that he had a $10 million mansion, and that he left to his new girlfriend.
And that was Pinto Walsh.
Yeah, Pinto Walsh. And what happened is that he wrote what's called a codicil, which is basically amendment to a will.
Okay.
And it was holographic, which means it was handwritten. Now, a lot of people say, well, a handwritten will without witnesses, that's no good. But actually in California, a handwritten will, and if it's identifiable as his handwriting, that will pass as a will, and you don't have to have a lawyer involved or anything.
Well, the controversy that I remember from this case was that, in fact, he had a major attorney, a large law firm, did estate planning for him, setting up the will and the trust, and these codicils, which raised and there was 2 codicils, and what raised the ire of the court in probate was the fact that both codicils kind of said 2 different things, and the judge, there was a gentleman named Judge Kane in Santa Clara County, I believe, was kind of a little leery of the fact that why didn't he use an attorney if he had already set up a whole estate plan, and now he's going to amend who he's giving his assets to in a handwritten will, not with no witnesses. And I also understand that it was written in like chicken scratch.
Well, that is kind of the things he'd like to have a drink or two, and actually we're going to do as our last segment something on DUI defense, and he had a DUI, he had a drunk driving, and apparently he liked to drink alcohol, and they're guessing, this is really speculation, that the reason it was written so difficult to read was because he was drunk when he wrote them.
Okay, well then that brings up the question of capacity, because when you're doing any kind of estate documents, you're supposed to have the capacity to be able to make the decision to give the assets to the beneficiary you're choosing. So was capacity raised in this?
Well, I think it was, but I think what's interesting on that whole issue is that to make a will, you don't have, testamentary capacity is a relatively low bar. And another thing that's a relatively low bar is getting married. I think it's a higher bar to get divorced. But I mean, it doesn't. Okay, to make a will, you have to know it's a will, right? You have to know who your children are, and you have to know where your resources are, right? So you have to know I've got a house on 15 Oak Street, and I've got two sons, Timmy and Wally, and this is a will. That's really all you have to know. You can think you're Napoleon and sign in Napoleon, but it doesn't matter. You just have to know those three things. So it's a fairly low bar. Now, if you're doing a trust, you have to understand the nature of the document, and you have to understand the consequences of signing it. It's more like a contractual level of capacity. So much more complex document. And the reason they do that is a will typically goes into probate, and a judge looks everything over. If you do a trust, you can avoid probate, and that's the reason a lot of people do living trusts. In the olden days, the only people who had trusts were like Rockefellers and really rich people, but then they changed it and said, well, regular folks can have a living trust, and they can put their house into that trust, and it can pass without probate. Probate is kind of a lengthy process, and there's a certain percentage that has to go to the executor and to the lawyer, and so a lot of people go in for trusts. Plus, they're easier to modify, and they actually write down specifically what do you want to do with your legacy. They're a little more complex.
Yeah, the thing about a trust, though, in a trust, you have to have a notary. So there is, it shows that there was capacity. Well, most trusts in California, you got to have a notary sign off. Not that the notary explains the trust, right, but that the notary witnesses the signing of the trust. And even amendments to a trust, technically, not a will. A will is a witness, or like you were talking about. But a trust, you need to have a notary sign. Even on amendments, you're supposed to have a notary sign off on the trust, showing that you were the person that actually signed it, not somebody else out of your family.
Well, okay, so there's different rules, but there's not really anything like a holographic trust.
No, there's not.
So,
no.
But I'm just saying there's different levels of capacity, and when you start looking at dementia and different things of lack of capacity, being drunk's not that bad. I mean, as far as not knowing what's going on, a lot of drunk people are pretty operational.
Yeah.
And so, just because someone's drunk doesn't mean that they don't have the capacity. And especially this guy seems like he was, a pretty...
But he was a very astute businessman.
No, but not only that, but he was an alcoholic who drank a lot all the time.
Oh,
and so probably he was used to that and still getting along. But anyway, yeah, that was because whether they could, not so much it was not very legible, but was he so drunk that he couldn't understand that this was a will he was writing.
So what happened with all of this? Did they go to court and have to fight it out there, Mark?
Well, this is where it gets interesting. Okay, so the wife, who's still the wife, even heading to be the ex-wife, but still technically the wife, finds out that the first holographic will is in 2011 gives the mansion and $10 million to Miss Pinto Walsh. And there's something about to create a museum for public to view his art. Now, this is a little tricky because that language makes it sound like maybe she's just a trustee and she doesn't actually get the $10 million in the mansion. Maybe she's just a trustee of it, and maybe she can get a salary, maybe 1% a year or something, right? And then maybe she talked to somebody, and then a little bit later,
they realized that codicil didn't sound so good, right?
Maybe she found out maybe this one's not going to fly. Yeah. So later, November 18th in 2012, there's a second codicil, and that one gives the $10 million and the mansion just directly to her.
Yeah, well, see, the second codicil it's much better for Miss Pinto Walsh because
right.
The problem with the first codicil, they were arguing that it starts creating a public trust,
right?
And she'd be the trustee of the public trust,
right? And I'd say
as
maybe
trustee, she would get nothing except a minor salary.
She might get 1% of the total, so that's
which
nothing.
Compared to his
$10 million
wealth,
and
compared to his wealth.
And the mansion, we don't know how much the mansion's worth, but probably something. And so anyway, then the separated wife, she starts not being happy about this. But on the other hand, the girlfriend, Miss Pinto Walsh, has stuff in her favor. She had the power of attorney over medical decisions, Vance Healthcare Directive attorney, and actually Kinkade made statements to his attorneys that he wanted Pinto Walsh to get something, to receive something. So she had stuff that, you know, she wasn't completely out of the blue. Plus, she was living with him. Um, so there you go there. But now the separated wife was not so happy about that, and so she was saying that, you know, this at the time this was all done, this paperwork was done. Kinkade had only been dating Pinto Walsh for about 6 months.
Yeah, well, from what I wanted to bring this into the family. This kind of brings it into the family law. So what I was really thinking right now is what I understood was they did a secret deal not to destroy his reputation, and as a result of that, we'll never know exactly what the deal was.